From the main list, item number 1.
My lord, we are here with the issue of rank and pay parity in Assam Rifles, my lord.
Sorry?
We are here with the issue of, my lord, rank and pay parity in Assam Rifle clerical trade, my lord.
Okay.
The issue, Lordship, is otherwise well versed with. In fact, Lordship had recently passed a judgment in respect of other trades also. But then that, my lord, has been carried to the Supreme Court. The Apex Court, my lord, as I know, my lord, has said recently that all other judgments on this issue should be placed in the next date fixed in July, my lord. That is the order of the Apex Court. Otherwise, there is no stay on Lordship's judgment. And in the meantime, my lord, I find that another judgment has been rendered by this Honorable Court in WBC 198 of 2019 in respect of 192 persons in the clerical trade, my lord. The status of implementation of the judgment, whether they are carrying it to the appeal or not, my lord, is not clear, my lord. These two preliminary things are there, my lord, before we go into the merit, my lord.
So what do you want to do?
My lord, the other judgment particularly, apart from what is going to happen in the Apex Court, the other judgment would have a bearing, my lord. If they implement, my lord.
Which are the judgments?
My lord, I'll have a copy.
Yes. Give us both the judgments. The other one also, which is pending before the Supreme Court.
Supreme Court, my lord, I have only one copy.
That's all right. Just my want the date and.
My lord. WBC 198 of 2019, decided on 17/2/23, my lord.
It is submitted on behalf of the appellants that the issue involved herein, pertaining to pay parity of certain employees in the Assam Rifles with those in the other Central Armed Police Forces, is substantially similar to the question that arose in WPC 198 of 2019 that was disposed of by a judgment of an order of February 17, 2023. Full stop. Paragraph, the appellants point out that such judgment has been carried by way of a special leave petition and such petition is pending, though there is no stay on the of the judgment of February 17, 2023. Paragraph. The appellants also submit that the date in the other one should be April 20, 2022. April 20, 2022. Full stop. And the appellants also submit that a recent judgment has been passed, and in the other matter, it should be WA 10 of 2022.
Yes, sir.
The appellants also submit that in a recent judgment of this court of February 17, 2023, passed in WPC number 198 of 2019, bracket Ajay Kumar versus Union of India, a somewhat similar question has been addressed, full stop. However, the appellants claim that if Assam Rifles has implemented the order of February 17, 2023, the same will have a bearing on the present matter, full stop. The appellants are also not aware as to whether such judgment has been challenged before the Supreme Court. Paragraph, let the matter appear when?
Sometime in the later half of July, my lord. Because
Let the matter appear 4 weeks hence, both to await the outcome of the specialty petition pending in the Supreme Court, and for Assam Rifles to indicate whether the order dated February 17, 2023 has been challenged or implemented. Yes.
deeply realized, my lord.
Only one?
Made, please.
What is this matter, Mr. Advocate?
This is the office of profit that matter.
Oh, this will take last, end of the board.
Yes. May I request for tomorrow, my lord, there was a meeting fixed at 11:30 for Hygiene Committee, so.
Tomorrow. Inform Mr.
Mr. Nath is here.
Nath.
Mr. Nath.
I will again take it up last on board.
Yes, sir.
From the minutes, item number 1.
Please, Your Lordships.
Yes.
My Lords, these matters are still pending before the Honourable Supreme Court.
Since there is no further development and the issue is still pending before the Supreme Court, let these petitions appear in the month of August 2023. Paragraph, the parties will have liberty to mention the matter for earlier listing in the event the Supreme Court matter is decided by them.
Highly obliged.
Item number 2.
Please, Lordship. I filed my rejoinder, Lordship, with regards to the affidavit filed by the state respondent and also regards to the electricity board, Meghalaya electricity board. The Lordship, in my affidavit, I have indicated in their para 15 and 10 of the affidavit filed by the respondents, state respondent as well as electricity.
What is the matter about?
This is regarding the load shedding, imposition of the load shedding, the cordon of electricity.
Yes.
They have mentioned as per that order, they have mentioned that the alternative arrangement had been made. But the petitioner have bring to the notice that there was no alternative arrangement for the essential service provider like hospital and any other.
Yes, we believe even hospitals suffer
Your Lordship.
load shedding.
Your Lordship, we have got a list of hospitals and other institutions where load shedding has been exempted because they had the dedicated feeder, Your Lordship. Now, in some hospitals, Your Lordship, because there's
No hospital, there is load shedding.
there's no high tension line, so that is why dedicated feeder could not be exempted.
But madam, over there are people who are on life support. And people who are on life support and load shedding, they'll just drop dead.
No, at the moment, Your Lordship, the respondents have taken steps to relax the load shedding hours by buying because we had written in our affidavit that we proposed to buy 53 megawatts of
From the
units
national grid.
from the NTPC, Your Lordship.
Yes.
So we have started procuring the units from the 3rd of June, Your Lordship. Then there is an ongoing process of purchasing electricity from the market also, Your Lordship. And because of the heavy rainfall, Your Lordship, the level of water has risen in Umbiam and also
It's only risen by 5 feet.
10 feet, Your Lordship. My instructions are that it has risen by 10 feet, and so some relaxation has been placed for load shedding, Your Lordship.
Very well.
So,
We'll monitor it. We'll keep it after 2 weeks. We'll see how it happens.
Your
But
Lordship, I also pray that we may be allowed to file an affidavit to place on record.
you file a status report, madam.
Yes, Your Lordship,
And,
we'll do
and
that.
what you take care of is that these essential services, like some key offices, the hospitals, and things like that. These are exempted.
Negrims is exempted completely.
Negrims is exempted, but Negrims also has its own facilities.
Yes, because of that. And the other hospitals do not
The
have
other
that high
hospitals, you have to
tension.
develop those facilities, madam.
Yeah, because they have a dedicated feeder.
You have to have a backup diesel generator set in every
Hospitals.
hospital.
That they have.
Linked to the key, it'll be linked to ICCU, it'll be linked to the neonatal kind of thing. It need not be linked to the general ward.
Okay.
But the diesel generator set should cater to so that there is seamless switchover.
That diesel generator sets are being used by all the hospitals, Your Lordship. Otherwise, it would not have been possible to function.
So you give us a
we'll give
a status report on that.
Your Lordship, just overall there is no reduction on the load shedding because that is the same thing happening. Means they have not changed
No,
any
that is not
timing.
correct, Your
They
Lordship.
will file a further report We are
Give a
recording her
statement.
statement that the Umiam waters have risen by 10 feet and therefore there is going to be greater power generation from there. She said that they're buying from NTPC. She's also buying from the open grid.
Marketing.
But at the end of the day, you'll have to pay for it.
Lordship, that
Is
is
this
not the issue.
someone's joke every time this matters?
Yes.
Otherwise, it doesn't go off.
Yes, Your Lordship, I know. It's just
Someone sitting outside waiting for this matter and then switching it off. Yes. The petition in public interest has been filed to address the issue of shortage in the supply of power all over the state and what the petitioner perceives to be the arbitrary plan of load shedding adopted. Paragraph. An earlier affidavit filed by the state has been dealt with by the petitioner and according to the petitioner, no rationale has been indicated in such affidavit as to why some areas suffer longer power cuts than other areas. Full stop. The petitioner points out that even essential services, such as government hospitals, are not exempt from power cuts. Full stop. Paragraph. It is submitted on behalf of the state that in view of the adequate rains over the last week or so, the Umiam waters have risen by as much as 10 feet, thus allowing greater power generation. Full stop. The state has also been purchasing power from NTPC, from National Thermal
Power Corporation.
From about the beginning of June. Full stop. The state is also looking at purchasing power from the open grid to augment the supply available. Full stop. Paragraph. As to uninterrupted supply of electricity to hospitals and the like, the state submits that by and large hospitals have been exempted from power cuts, provided that provided they are connected by high tension feeder lines. Full stop. It appears that even the civil hospital in Shillong does not have a high tension feeder line that caters to the entirety of the hospital. Full stop. The state also says that Negrams, the full form, has been spared any power cuts. Full stop. Paragraph. Apart from the fact that hospitals across the state and the healthcare centers elsewhere need to be improved qualitatively with better equipment, more experts and greater facilities, the most elementary thing that must be ensured is the uninterrupted supply of power to such places, as power is essential in running machines for patients on life support and possibly supply of oxygen. Full stop. The state should make every endeavor to ensure that even if the need arises in future to restrict the continuous supply of power on account of any shortfall, hospitals and like institutions are exempted, or there is backup available by way of diesel generator sets for such for the hospitals and like institutions to run seamlessly and unaffected by power cuts. Full stop. Paragraph. It is hoped that with the regular rains in the recent times, the situation improves. Full stop. However, there must be a plan B in place, which should be both rational and equitable, even if power cuts are resorted to. Full stop. The state's status report should be filed before the matter appears next. A fortnight hence. Full stop. A copy of such report should be made available to the petitioner at least a day in advance. Yes.
Let's press Lordship.
Item number 3.
State's appeal?
Lordship, this is an appeal against acquittal.
Acquittal.
Acquittal. So state is a state appeal against acquittal, Lordship. Lordship, a very limited issue involved.
What was the charge?
302, Lordship.
302.
And the limited ground involved here, Lordship, is this the Lennet trial court had found the statement under 164 contradictory. And he said because it's slightly contradictory on a very technical ground, so it cannot be relied upon. Based on that, it has given acquittal. And Lordship, the state submission is this, that is not a ground for acquittal because there are two statements under 164.
But then it becomes very difficult if 164 is going to be made the only basis.
Lordship.
There has to be other circumstances. There have to be other circumstances.
Absolutely. That has
164 can only be corroborated.
Corroborated, Lordship. Lordship is correct.
164 on its own.
Here is a situation, Lordship, that there are other evidence of the witnesses which has to be corroborated. That has been grossly overlooked. The murder weapon, Lordship, it was not a weapon, but it was a rope that was discovered at the by the leading evidence by accused under, which is under section 27 of the Act, Lordship. And besides that, Lordship, under the 164, the substance in 164, Lordship, is that the grave was dug in the morning by one of the, and this fact has emerged out of 164. So that part has been overlooked. Grave was dug in the morning, The statement of both the accused, Your Lordship, which was confessed in 164, they tend to corroborate each other as to how the murder was carried out.
Yes.
So, Lordship, this is basically the ground. If this finding can be reversed on the basis of evidence, Lordship, then the
It is
acquittal.
an open appeal, so
Open appeal, Lordship.
everything can be looked
Lordship,
into.
yes.
My lord, just one aspect which I would like to remind this honourable court, my lord. If your lordship recalls, I had raised the issue of maintainability of the appeal, and thereafter the memo of appeal has been amended, and an application craving leave of this honourable court to prefer an appeal against acquittal under section 378, that has also been filed. But at that point of time, the condonation application was not filed. Your lordship had rightly pointed out that since the appeal itself was not maintainable, so the delay is still running. Though, my lord, wide order dated 8 February 2022, passed in criminal miscase number 6 of 2021, your lordship had had condoned the delay at that point of time. But your lordship, now since the amended appeal has been filed recently, so the number of days of delay, my lord, it should not be one.
It's technical.
My lord, it is technical, but my only humble prayer before your lordships is that only the submissions which I make may kindly be noted, and it may be taken.
That is our prerogative, madam. Whatever you make, what we write is our prerogative. And you are no one to dictate there.
My lord, I just.
Go and complain elsewhere
No, my
that you
lord.
said this and this is not
Absolutely not.
recorded.
Absolutely.
Sit down. Carry on.
May I please, Your Lordship. So, Lordship, if may I take Your Lordship to paper book 1. Page 12, Your Lordship.
What is that, page 12?
Lordship, this is statement 164.
Page 12 is the 164.
Sorry, Lordship. Page 12, we will just come.
164 of the two accused.
Two accused, Lordship.
So which appellant is this?
Lordship, we'll just take the type copy will be at page 20, 23, Lordship. This is the first accused. This is second accused, Lordship, page 23.
This is by, statement is by?
By the second accused, Lordship. And Lordship, if we take through
What
page
is the name of the second appellant?
Bonnie.
Momin.
Bonnie Lingdo, Your Lordship. Lingdo. Bonnie Lingdo, Lordship.
Bonnie Lingdo,
Lingdo.
yes. I thought Bonnie Lingdo was same as Bernard Lingdo.
And the first accused is Bonnie Lingdo, Your Lordship. Bernard. First is Bernard, second is Bonnie, Your Lordship. So this was Bonnie at page 23. And Lordship, page 37 is a type copy of
23.
23 is the Bonnie.
Yes, sir. Where is Soshan?
Soshan, Your Lordship, just next to Dreamland.
Next to?
Dreamland from Police Bay, Your Lordship, there's a Dreamland. Just after the bridge, Soshan starts.
And where is of Bernard?
37, Your Lordship.
No. This cannot be the basis for conviction. Completely contradictory. Show us section 27.
Lordship.
The statement and then the evidence on how the rope was found.
Lordship, we just come to page 336. 300. Page 336 of paper book 1.
336.
Lordship, yes. Hmm. 336, Your Lordship, is the third
I have not
paragraph.
recorded the statement of Bonnie in presence of any witness while he was giving a statement regarding recovery
Lordship.
of material exhibit 6.
Lordship, the next part, Your Lordship. The next
The
part.
IO.
Lordship, yes. Lordship, the material exhibit 2, the rope. Lordship,
Material was seized from an open space near the graveyard where the victim was buried. Then, but no one let him.
after the arrest of the accused, Your Lordship.
After the arrest, it was revealed that material exhibit was used to kill.
So Bernard Power,
But they did not admit that was the rope.
Lordship, they did not admit, yes. But the discovery
A,
of
they did not admit that was the rope. B, they did not lead you to the rope.
Lordship, their leader.
Where is that?
Bernard Power, Your Lordship. Arrest of accused. Bernard Power, it was revealed.
After the arrest of the
Exhibit 2, Your Lordship, was discovered.
No. This is not leading to the rope. After the arrest of accused Bernard Fawa, it was revealed. It was revealed does not mean Bernard Fawa revealed it.
Yeah, Lordship may be correct, but the statement goes, Your Lordship, only after the arrest of Bernard Power.
They may have done it, but beyond reasonable doubt, unless there is something else, no.
Lordship, just come to page 338. Same IO, Lordship. Besides the incriminating evidence,
See the date. Yes.
besides the incriminating evidence, material exhibit T seized in this case,
Yes.
another incriminating evidence in my investigation is that the graveyard which was dug to bury the victim in the morning of 18 February
No
2006.
conclusive proof. There would be at least blood marks.
Lordship, it was a case of strangulation by a rope.
Or strangulation by a rope.
Right, yeah.
All right, there may not be, but there may be. It could have been tested for DNA. You may not have the facilities. We know that, but that does not mean a man has to hang because you don't have the facilities.
Lordship, what? Here, Lordship, the case, Lordship is very correct because it's slightly peculiar circumstances that the grave was dug in the morning.
There is a perfectly good example, which not example, perfectly good explanation given by Bonnie. Bonnie says that he died on my lap
Lordship,
when Bernard went to buy a cigarette,
Lordship,
and when Bernard and both of them were nervous,
Lordship,
and to the effect that Bernard rubbed the sole of Biplop
Lordship,
is corroborated by both.
Lordship,
But Bernard says, I saw a rope and Bonnie had killed. And Bonnie says that he died on my lap. Now you can't take a statement of an accused against another accused too.
Lordship, section 30 of the Evidence Act. I'll just take help of that.
We'll look at that, but you cannot really take the statement of one accused.
But Lordship, one accused is clearly stated. Only one accused is clearly
That
stated.
is not a confession. He then becomes a witness to the incident.
Lordship, yes.
And what is the corroboration of such witness statement? When he wants to get off the news himself, he is a co-accused.
Lordship,
He
yes.
wants to get off the news by assigning the entire blame, attributing the entire blame on the other accused. But now see section 30. What does it say? There is no confession. Where the commission of offence, there is no confession. It's an accusation. Section 30 comes into play when they say that both of us jointly strangled him. That would amount to confession. But here is a unilateral accusation.
Lordship, if I'm just allowed to read.
When more persons than one are being tried jointly for same offence and a confession made. Where is the confession?
Lordship, and a confession made by one of such person affecting himself and some other.
Is proved. Where is the confession? First, show us the confession.
Lordship,
show us the confession first.
Lordship, in the confession statement, he has stated about
No. Forget the nature of the statement. What is confession? Confession is acceptance of the commission of the offence with which he has been charged.
Lordship.
Where does Bernard do that?
Bernard does not.
The moment Bernard does not do that
for himself, Lordship.
The moment Bernard does not do that, it's not a confession.
But Lordship, Bernard has done for the other.
No, it has to be made by one of such persons affecting himself and some other.
Himself.
You can't divorce it.
Affecting himself and some other persons is proved.
Is proved. It has to be proved.
Lordship.
It's not been proved. The statement also has to be of such quality that it affects himself and some other. This does not affect him.
Lordship,
nor is it a confession.
Lordship, so far affecting, rubbing the soul and the body lying in his lap.
No.
That is
confession has to be of the commission of the primary offence. You can charge them with 201.
But Lordship, some other of these such persons, both were together in commission of an offence. Lordship is correct. Lordship is correct.
We've grown up with this.
Absolutely correct.
This 30B. You have to, let us say the two of us, we are accused of assaulting you. And I say that I held your feet while he hit you. That's admission?
Lordship is.
So there has to be an element of admission to committing the offence or being a party to its commission. Once that is made, that will be regarded as a confession. That's one. It has to affect the person, the maker of the statement, and some other co-accused. That's number one. Second is, when that is proved, then you can count it against the co-accused, relevant co-accused.
Lordship.
So, first it has to be a confession. This is not a confession, this is an accusation. And it's elementary that evidence of co-accused against another cannot be taken cognizance of, because after all he's trying to get off the hook himself.
But Lordship, then if you take not a confession, then you can take the statement as a
Take it as a statement.
statement. Lordship,
Take it as a statement.
Lordship, this part of page 30. Lordship.
How is the corroboration? Let's take it as an ordinary statement
Lordship.
of a witness called by the prosecution.
Lordship.
Now, how is it corroborated?
Lordship, it's a direct evidence.
What direct evidence?
I saw Biplov was strangled to death with the rope by
Very good. What is the corroboration of that?
Lordship, unfortunately, there can't be any corroboration here because there was no murder weapon, first of all.
A, it wasn't even discovered at the instance of the accused. B, it's in direct contradiction to the previous 164 rendered by the co-accused that he died in my lap. And the incident occurred when Bernard was away. Bernard was walking in after buying the cigarette and possibly did not see the act of killing, but immediately after the killing. He said, I saw a rope strangled. So the act of killing, the act of strangulation may not have been witnessed by Bernard, or at least his statement does not make it
Lordship
out.
is very correct. But in a situation like this, Your Lordship, there could not have been any other witness.
This is poor investigation, and we are not, your life support for poor investigation.
My respectful submission, Your Lordship, would be if we don't argue, maybe Your Lordship is correct on the confessional part. But so far, Lordship, the strangulation and the death is concerned, then we can take help of the oral evidence. And in a situation like this, where there's two of them were present, there was nobody else.
Yes. Word against word. So something else which will discredit one and which will, prove one the other to be right.
Lordship, this particular statement was neither retracted, nor denied even in the 313.
He was not required to do anything.
No, Lordship, but there's no retraction. Neither he came himself as a witness in a defense. Only thing is
retracted. Bernard had to retract it.
Lordship, he did not.
There's no, just because Bernard does not retract it does not mean Bonnie goes to hang.
No, Lordship. Bernard had, when 239 stage was over, he had to offer himself as a witness, and then the prosecution could have cross-examined him. He chose not to. He missed that stage. Second was Lordship in 313.
No, nothing.
Lordship in 313, even he did not retract. Then we are left with a situation, what would be the...
You're left with a situation where one dead body is found with two people and both accusing each other, or one denying and one accusing. Nothing else.
Lordship, both were involved. One, the intensity was less, dying in the lap. The other saw the other strangulating. And that rope, the murder weapon rope... Lordship,
tell us, how is that allegation proved?
Lordship, the proof is because of the statement of Bernard, which according to me...
No. Just a statement is an allegation. A statement is an allegation. Is proved means something in evidence. How is it proved?
Lordship, the corroboration of that rope, the murder weapon, was
no one took you to that murder weapon. Neither accused took you to that murder weapon. You don't even know whether it was the murder weapon.
Lordship, but the seized material from the PO.
There was a rope. In a graveyard, there will be rope. People lower the casks with rope.
But Lordship, there are other evidence to show that all the three traveled together in the same place. Same auto.
That's neither here nor there.
They had traveled together in the auto.
Neither here nor there. They admit it. They don't deny it. They admit it. And it comes to an incident where there's no animosity, there's no enmity, there's no motive that you establish.
A motive was there, Lordship.
What motive was there?
Motive was ransom. The issue of kidnapping was there, Lordship. The FIR was filed by the principal of a college, and the father was in Siliguri. He was called, and there are other evidence, Lordship, relating to the cause for they wanted to demand money from the father. They could not extract the money.
Did they demand money?
Lordship, yes. But that evidence...
Did they demand money?
Lordship, yes.
And is that proved?
That demand proved, that is not being proved, Lordship.
Then?
Because there were too many phone calls from Shillong.
Well, terrible investigation.
Lordship,
probably paid off. Probably corrupt investigation.
Unfortunately, Lordship, a life has been lost.
Mad luck. Put your house in order. Get them to investigate properly or not accept bribes.
Lordship, we agree, Lordship, that this case has some problems, no doubt about it.
We are not the substitute for proof. We don't produce evidence.
But Lordship, even if you argue on circumstantial evidence, right from the time of travelling till the date, Lordship, I agree that who pulled the rope? Who pulled the rope?
We don't even know whether it was a rope. You're jumping too many guns.
Lordship, but
You're going on to the rope.
But the only motor weapon recovered was rope from the PO.
What does the postmortem report say?
Postmortem strangulation in Lordship.
Strangulation.
Lordship, yes. There's a corroboration by the postmortem.
That's the only one. That's the only one.
Lordship.
You ought to have said it before. That's the only one.
Lordship was coming to that because we have to overcome the confessional part.
Now, the rope is not linked to the commission of the offence.
It is, Lordship. As per the postmortem report,
rope is not linked to the commission.
rope.
That
Lordship.
rope is not linked to the commission of the
Lordship,
offence.
postmortem cannot say rope. Exactly. Postmortem at the best can say the cause of death. Whether by incisive, if it was a knife, then it will give into the intensity in which it was given.
Strangulation can be by hand also, where fingerprints will be left.
Lordship is correct. But here is
Strangulation can be rope. Strangulation can be by a dupatta also,
Lordship is correct.
which will be smoother.
But here, Lordship, the
rope
corroboration.
will leave some marks.
Lordship,
Then your rope should have been tested, whether the rope was of the strength to kill a man or not.
that was not done.
We don't know what kind of rope was it. Was it a string to tie a plastic packet, or was it a rope used by the Navy to anchor boats?
Lordship is correct. That was not done. But Lordship, the
So it
corroboration.
was shoddy investigation. But we don't fill in the blanks. It has to come to us with the blanks filled in.
Yeah, Lordship is correct. Circumstantially, Lordship, at least we can build up a case of
There's
circumstantial.
nothing circumstantial about it. 3 people went on a boat. 1 comes back dead. It's incumbent on the both of them to indicate. They've indicated. And there's no conclusive evidence as to how he met his death.
Except for that, Lordship is correct.
You hang them?
Except for corroboration.
No, not in a civilized society, no.
Lordship, just allow me to at least check the records once to see how was the murder weapon.
You want some time, you take some
Lordship,
time.
yes. At least
On
to-
substance, it's zero.
On whether they.
Take some time, we'll give you time, but substance is zero.
At least
No judge could have,
will confirm
no judge
from the-
could have passed any other order of this.
Next week, Lordship, at least let's ascertain that part of discovery of the whether it was done as a BS or not, because the evidence of IO is not.
After the hearing, after considerable hearing, the state seeks time, full stop, let the matter appear, a week hence,
Lordship.
paragraph. At the outset, a technical ground was sought to be urged on behalf of the respondents to the effect that the appeal that was originally filed was not in order, and when it was subsequently sought to be filed, no appropriate application was taken out for condonation of the delay, full stop. The point that is made is that since the original appeal may have been incompetent, the extent of delay that ought to have been explained should have been till the rectification application may have been filed, full stop, paragraph. The footy little technical glitches are liable to be overlooked, particularly since, this court is convinced that in essence, the state had intended to and did file the appeal, though the state may have adopted an erroneous procedure, therefore, full stop. Further, it does not appear that the state intended or deliberately delayed, intended to or deliberately delayed in the filing of the appeal, and the fact that the appeal may have been in wrong form at the time that it had been filed would not imply that till the form was corrected, the delay had to be attributed to the state, full stop. paragraph, all technical points sought to be raised on behalf of the respondents are repelled, full stop. The hearing has commenced on merits, full stop. It will be on merits only that the matter will be heard further.
Deeply obliged, Lordship.